First, thank you all for your attendance. I'd just like to welcome everyone to the meeting. Just checking that everyone's got good reception and can hear clearly. There is a webcast also taking place as part of the DPEA Scottish Government programme to open up its business and make procedures available to the public. I'm not aware at the moment that anybody's taken advantage of that. So first, I'd just like to go through and identify the participants. And I understanding that we have first for the applicant, Ian Smith.
That's correct.
Yeah.
Yep.
Craig Wallace.
Yes, good morning.
Lisa Proudfoot.
Yes, good morning.
Lisa here. Now, hang on a minute.
Just before you go, can I just check? So if I'm just doing this normally.
Is that I've got Lisa's picture up. Sure. Oh yeah, right. We've got Lisa there.
Morning.
Now, good morning. And then from the council, I've got Paul Devaney.
Hello. Yeah.
Donald. Yes, I have those two. And then the interested party, the Academy Music Group, Ewan MacLeod.
Good morning, sir. Can you hear me okay?
I can hear you okay. For some reason, I've got you under Emma Henry's name. I don't know if that's...
Yes, it's a guest appearance as Emma Hendry today. Sorry, we've had a bit of technical difficulty at our end. We've not been able to hear anything so far, but I'm assuming we've not missed anything important. So I'm quite happy to proceed on that basis.
So can you hear me now?
I can, sir. Yes.
Yes. No. Basically, I'm just checking the attendance. So is Emma Hendry with us?
She is. Emma Hendry is one of my colleagues. Works with Shepherd and Wedderburn, so she's in the room with me, along with Mr. Graham Lang, who's the planning consultant for the Academy, and also Miss Lindsay McIntyre, who is the acoustic consultant. So they are all in the room with me and can all hear you.
Thank you. And Keith Forshaw.
Yeah, here.
You're here from Property Manager Live. And then James Russell, the interested party we appear not to have. And I've also got a Richard Slipper, who's not on my list. Could you introduce yourself, please, Richard?
Will do. I'm representing Marco's Leisure Limited, the current owners of the development site, who are in a conditional agreement with Watkin Jones Group post the development to transact to sell the land. Previously, the owners of the now O2 Edinburgh Corn Exchange. So I represent Marco's Leisure Limited as a planning advisor. Thank you.
Right, so you're an interested party as well. Right, thank you. Now I'm trying to make notes as we go along. So if I have a hesitation, please just bear with me. Now, first of all, just looking at the items on the agenda, the purpose of the meeting. The Scottish ministers have appointed me to consider a proposal for mixed-use development, including 309 built-to-rent homes and student accommodation of 406 bed spaces, with ancillary developments, including commercial uses, demolition, public ground landscaping and access. All this largely on the site of the former agricultural market at Newmarket Road in Edinburgh, adjacent to the O2 Academy, an existing music venue that operates under a planning permission granted in 1998. Now, Section 41A of the Town and Country Planning Scotland Act 1997 is amended, enshrines the agent of change principle. I'm sure you're all now familiar with this, but in brief, it requires a planning authority to take into account whether permission for a noise-sensitive development includes sufficient measures to manage the effect of noise from an existing cultural venue. If permission is granted, conditions must not impose additional costs on that venue in order to mitigate, minimise or manage the effects of noise. Now, in this case, the council informed ministers that it was minded to grant planning permission subject to conditions. In response, the ministers instructed the council to refer the application to them for determination, so that further consideration of the agent of change principle and implications for live music venues and the recovery of the nighttime economy, as ministers consider this to be an issue of national significance. So this is not an appeal, but a planning application. The ministers have asked me to consider the application, especially regarding the agent of change principle, and to report to them with my conclusions and recommendations as to whether or not planning permission should be granted, together with any appropriate conditions. Now, at the outset, the applicant suggested there'd be benefit in some discussion between the key parties and the reporter to ensure there is no confusion on what has and has not been considered and agreed. I therefore agreed to consider this, to consider options for such discussions and agree the best way forward, to ensure that I have all the information necessary to inform my conclusions and eventual recommendation to the ministers. Now, I'm sorry we had a little bit of difficulty in actually coming up with a date for this, but now that we're here, I hope we'll be able to move forward in a constructive manner. Now, following through the agenda, matters for consideration, the Council's committee report sets out in detail the issues it considers in relation to the application as a whole. Now, I note that the ministers are content with the listed building application and have left that for the Council to handle. Of the other comprehensive issues that the Council dealt with, the agent of change principle is the only one picked up by the ministers, and I suggest that this is the issue for me to concentrate on at this and any subsequent procedures. Perhaps I could have parties' views on this, starting with the applicant.
Thank you, sir.
Yeah,
so I'll address that point. We are content that the agent of change is the sole item to be dealt with through any further procedures. We have been reviewing the circumstances, the correspondence, etc., post minded to grant decision, and indeed have taken some advice on matters there. To inform the discussion today, there are a few suggested points that we would suggest would be useful to progress prior to agreeing the nature of any further procedures, and whether these can be dealt with by way of further written submissions in conjunction with the procedure. I would suggest would be subject for further discussion throughout the meeting today. First of all, we would like to suggest that there's scope to look at a statement of agreed matters. Now, in light of your comment there around agent of change being the only matter, if that is the case, then perhaps that can be confined to agreed points in relation to the noise assessments and the consideration of noise matters where there is agreement between parties. We would like to offer that up to be developed between all parties involved. Really, that's at your discretion as to how that is dealt with down the line. It may be something akin to a planning statement or planning commentary on it relative to some of the technical matters as well to be fed into that. So that was our first point, a suggestion. I've got a few others if you can please bear with me as we go through.
Please go ahead. Just to say on that first point, I'm very happy with that. Statement of agreed matters is always helpful at any hearing or inquiry. Obviously, taking into account as many parties' views as we can.
Thank you, sir. The second point is a somewhat unusual one and a technical legal point that has been flagged to us in consultation. And this really relates to the procedure that we are in just now. And it has been highlighted to us that the consideration of Section 41A relative to the call-in procedure has some anomalies. Now, this is something that we would like to flag and seek views on. Essentially, Section 41A clearly is a statutory duty on the planning authority, the determination of the application, and they have looked at this in the context of their report to committee. However, it has been flagged to us that looking at how Section 41A is treated in relation to a call-in procedure, there would appear to be either an error in drafting or an omission, or whatever reason we do not know. But in terms of how or where Section 41A is or is not referred to in the powers conferred on Scottish ministers to consider this by way of the call-in. So this relates to Section 46 and Section 48 of the Act, where there is no specific reference to Section 41A. So the advice we have received is that this is a matter that needs to be considered and may be helpful to encourage submissions from parties as to the interpretation of this and how it is therefore translated into the consideration of Section 41A in any forthcoming procedures.
Right. Is this something that you've shared at all with the other parties at this stage?
It is not at this stage, and it's only come to light in the last matter of days through review of this process. I don't think it. Clearly, we have the agent of change principle and now formally enshrined through NPF4 and policies 23 and 31. But in relation to Section 41A and how it relates to the Act itself, this is something that has been flagged to us. It may not be a massive issue in the context of where we are, but we've been asked just to seek clarity on the interpretation of that.
Right, thank you. As far as I'm aware, there have only been 3 cases considered by ministers. One was a written submission case in Glasgow, which is now dealt with and out of the way. But there's a parallel case also in Glasgow regarding a housing development adjacent to a music venue, very similar to this. So I suspect that this issue you've raised is possibly one that's not been brought before ministers before. And it's certainly not an issue that has been drawn to my attention, although I can fully understand from what you've just said why you would wish to examine this. Is this something, Mr. Devaney, that the council has ever come across?
Thank you, sir. No, it's not. I mean, I think as you've highlighted, the agent of change has been a fairly recent change in terms of the statutory, bringing it into consideration under Section 41A, and certainly we're aware of the 2 cases in Glasgow. I think the first one you referred to, King Tut's, a decision has been made on, and we've been also following the other case at Canderrig. So it's not something that we're aware in terms of the point that I think that's been made by Mr. Wallace, but we'd certainly appreciate possibly seeing a copy of the information, and we could look at that and comment on it. And I suspect other parties would probably be of a similar view.
Thank you. Mr. MacLeod, is this something you've been made aware of?
No, sir. This is the first I've heard of it this morning, which is regrettable. I think if I could offer a suggestion, it's nobody knows at this stage whether the applicant is taking any point in relation to this or what point that might be. If there is to be a point taken, then it seems to me that it would be for the applicant to make that first, and for other parties then to have an opportunity to consider whatever the applicant's point is and to respond to that as they consider appropriate.
Thank you. Mr. Wallace, in a sense, what is the point behind this? Is there a question as to the validity of the minister's calling on this, as to whether they actually have a power to determine, possibly because of some lack of cross-referencing in the Act itself between parties or between sections, which was perhaps not anticipated at the drafting stage?
No, sir, that is not our point here at all, and we're not questioning the validity of that in any shape or form. It is more just around seeking clarity as to how Section 41A will be taken into account in the minister's determination of the planning application, following on from any procedures here.
Right. From my perspective, unless something contrary comes up, I would anticipate dealing with this in the general manner that we would any planning appeal, where we look at various discussions and the relevance, particularly to Section 25 and the development plan, which of course now includes NPF4. Perhaps the best way forward might be if you could perhaps send me a formal note of your concerns, which then could be addressed by the other parties, rather than trying to take this forward now, where perhaps we don't have all the necessary information, such as the act, immediately in front of us. Would you be happy to proceed in that way?
Absolutely, sir. We'd be more than happy to do that, and I apologise for the somewhat surprising addition of this at a late stage, but this was only brought to light in the last couple of days. We do not have the full detail around that, hence why we would like to encourage legal opinions on it, and we are happy to provide that and for other parties to thereafter comment.
Thank you. Mr. Devaney, are you happy with that?
Thank you, sir. That would appear eminently sensible.
Yes, and Mr. MacLeod?
Yes, very happy with that. Thank you, sir. Thank you, Mr. Wallace.
Okay, I'll make a note of that and make sure that that's incorporated in my note of the meeting, which incidentally I will be circulating very, very shortly, so that everybody knows where we are and to give anybody an opportunity to comment on that.
Thank you, sir.
Now, you have a second. Any further points?
Yes, if you could bear with me, sir. I've another couple of points just to flag. We were made aware of the O2 technical report prepared by KSG Acoustics. I think it was dated the 24th of March and submitted as part of their first representation to the application. Now, prior to this point, we have not the opportunity to review in detail or indeed comment on the content of that report, and the report itself indeed comments on the applicant's noise assessments that were prepared and submitted with the application. We would request, with your agreement, sir, that the opportunity to review and provide comments on that to help narrow down matters in dispute in relation to the basis of the noise assessments and the assumptions therein.
Are you still there, Mr. Wallace?
I'm still here, yes.
Sorry, I thought you were continuing there. Is that?
No, if you could note that, please, sir. The final point I would like to flag is in relation to recent engagement between O2 and their advisors with the applicant and the applicant's solicitor regarding suggested measures by way of further mitigation. Noting suggested conditions and an approach relating to the potential use of a deed of servitude. We have not responded in detail to those to date, pending your review of the requirement to do so and how that relates to procedures. However, if you have a mind to encourage us to do so, we would be happy to look at those conditions, and would suggest that the council should be encouraged to look at them as well, relative to what was previously proposed. In relation to the deed of servitude matter, it's been suggested that this has been used to good effect in cases south of the border. But we would be keen to understand if there is any evidence or indeed advice as to the application of that process to be used in a Scottish context. Again, just for clarity, to see if that is something that is appropriate to be progressed.
Thank you. On your third point, in terms of comments on the O2's technical report and an opportunity to discuss and possibly agree matters further, I think we've obviously a significant amount of time in hand before further procedures come into play. So I would hope that there would actually be time for that point to be taken on board, and I would hope Mr. MacLeod, you'd be happy to go along with that?
Yes, sir. Very happy to go along with that. I think, as Mr. Wallace says, the more that can be agreed in advance of any formal oral procedure, the better. So we would welcome any comments on the KSG work and happy to discuss that with the applicants as appropriate.
Mr. Devaney, I'm not at this stage including the council in that discussion. Obviously, if you wanted to take part in that, I'd be very happy. The council's position is made clear in the committee report and in the submission to ministers. So I'm not sure to what extent you might want to be involved in such discussions, but obviously we would want to keep you informed at every stage on how that was proceeding.
Yeah, I think, thank you, sir. I think it just possibly the issue concerning conditions that was raised might be the issue that's of most pertinence to the council as planning authority. So we would certainly appreciate being kept into that discussion. But I think there wouldn't really be any disagreement with the 4 points that have already been made by Mr. Wallace this morning in terms of the approach and trying to narrow the areas of concern down and having further dialogue.
Thank you very much. I've got conditions on the agenda later on, so perhaps we can leave those until that point. Are there any more points at this stage, Mr. Wallace, from you?
No, thank you, sir. That's fine for me.
Mr. Devaney, anything further from you at this stage?
No, sir.
No. Mr. MacLeod, any comments on you from what's gone before, or points you would like to make for my further consideration?
Yes, sir. Just a couple of points. One in relation to the issue of any review of the KSG report. I appreciate what the council's position as planning authority is in relation to this application, but what Mr. Wallace is suggesting, I think, is an initial technical review by presumably an acoustic consultant. I suspect it may be helpful to you, sir, to understand what the council's environmental health team's position on the KSG evidence is. And you may appreciate from having read the consultation responses and the committee report that the council's environmental health team has significant concerns with the noise impact of this development. Now, the council as planning authority took a decision in the round, if I can put it that way, that it was minded to grant planning permission. But what we're talking about in this context, particularly given the focus of the further procedure that you're looking at, is detailed noise evidence. And I would therefore respectfully recommend that you invite the council's environmental health team to comment on the KSG information as well.
I'm certainly happy to take that on board. I'm sure, Mr. Devaney, you'll appreciate the sort of subtle difference between what advice was given and perhaps adjusted in some way. This also relates, of course, to the conditions as well. But I would be happy for the council to be involved in any of those discussions. Mr. MacLeod.
Yes, just one further point in relation to the engagement on conditions and also the deed of servitude. My understanding was that you had already asked the applicant to engage with us in an email from over a month ago, and we would certainly welcome comments from both the council and the applicants on the conditions that we've put forward. So far as the deed of servitude is concerned, we have an opinion from a professor of conveyancing that confirms it would be competent to use it in a Scottish context, and I'm happy to share that with the applicant's solicitor if that would be of interest to them.
Thank you for that. Conditions we will come to. The deed of servitude, I'm not particularly familiar with its use in this context as you're suggesting. So certainly it would be interesting to have opinions on that and how it might or might not be fed into my conclusions. So we have a number of points there which are dependent now on further discussions, particularly between the applicant and the Academy Music Group, but also bring in the council as well. And I'll set that out in my note of the meeting, on which everybody will then have an opportunity to comment. So I think that covers the initial views that had been put forward and discussed. So if we could now move on to the information that's been already provided. Now, I already have a comprehensive list of submissions from the papers that were included in the original application, and those made subsequently by the applicant, the council, or third parties, notably which is the Academy Music Group. Now, are there any areas for discussion that require further written submissions from any of the parties in relation to the content of any of these documents prior to taking matters forward? And I'm thinking of documents in addition to those that effectively have been implied in the discussion which we've already had this morning, particularly in relation to noise and the various legal matters. Mr. Wallace, perhaps we could start with you on that.
Thank you, sir. I would maybe just revisit my first point in relation to the progression of a statement of agreed matters, which perhaps then could allow refinement or narrowing of the subject matter in relation to a further statement on interpretation of planning policy relative to the approach here. Now, whether that's dealt with as a further written submission or if we are looking towards a hearing, perhaps it's more appropriate as a hearing statement, but I would certainly encourage further exchanges between the parties to make sure that we can explore those matters.
Thank you. Anything else?
Not from me, sir. Thank you.
Mr. Devaney.
Nothing from me, sir, at this moment.
Anything further, Mr. MacLeod?
I think just in terms of the procedure, so nothing on the substance. I agree with what Mr. Wallace has said about the benefits of a statement of agreed matters. I'm just thinking about procedurally how best that might be achieved. That there's some information that's before you already, which sets out the third party's position clearly, namely the KSG report and the suggested conditions and deed of servitude point. We don't yet know the applicant or the council's position on those documents. And I'm just wondering whether before we get to a statement of agreed or finalising a statement of agreed matters, whether it would be helpful to have those parties' position on those matters to see whether the Academy Group is then in a position to agree with what they have said. In other words, we have a round of written submissions before we get to finalising a statement of agreed matters.
I think that would certainly be a sensible way forward. Normally in appeal cases with statements of agreed matters, it's a matter between the planning authority and the applicant stroke appellant to sit down and put forward a list which can then be taken into account by the reporter as matters which hopefully don't need any further consideration. It is simplified again in this case because we are only looking at the issues of noise. But what I would hope would take place would be initial discussions, perhaps from Mr. Wallace setting down matters on which they think an agreement is possible, and then taking into account the views of O2 and of the council. I would expect that would possibly be a written submission matter. It might also be a need for around the table discussion between parties, not necessarily involving me. And if parties could liaise on that, I think that would produce the best way forward. And I'll put that down in the note of the meeting. Would that be satisfactory?
Absolutely, sir. Yes.
Absolutely, sir. Yeah.
Yes, sir. Agreed.
Thank you. Now, any further documentation requirements? I have obviously a very comprehensive set of documents related especially to noise matters and the building solutions which are relevant to this case in terms of addressing those. But are parties aware of any further documents that may be required? And in the event of that, whether further written submissions on these would be needed? And I'm really seeking advice from parties on issues broadly within the noise and the mitigation issues around that, as to whether we already have sufficient documentation in place or whether further documentation is required. I'm taking into account that we have the issues over the noise assessments at present, which will be considered, but are there any other matters in addition to those assessments that we might need? Mr. Wallace.
Not at this stage, sir. Thank you.
Mr. Devaney.
Not at this stage, sir.
No. Mr. MacLeod.
The only documents that I thought might be of assistance to you, sir, are two documents or two parts of the same decision that have been referred to already, and that's the decision of Scottish ministers in the King Tut's case in Glasgow, which might be of assistance to you as it sets out the approach that another of your colleagues at the DPA has taken in relation to the agent of change, and the approach that ministers have taken in relation to that matter as well. Now, it's a question for you.
David Little, are you thinking of?
I am, sir, yes.
Right, I will undertake to get those. Perhaps you could just confirm the specific titles of the document to me, but I'll make sure that I have those, and then we can make sure that everyone has them and has an opportunity to comment.
Thank you, sir. If it would be helpful, what I could do after this meeting is arrange to have links to the reporter's report and minister's decisions circulated to all parties and obviously to your case officer so that you can get access to them as well.
That will be helpful. I have had a very preliminary look at those, but not in any sort of detail. But if you could do that, that would be very helpful. Right. Now, we've come along now to item 6 on the agenda, the procedure. Now, normally, there are 3 main procedures for reporters to consider in deciding how to progress the case. Written submissions, in which I study and decide if I have everything necessary to make the recommendation, and if not, request further comments in writing. Second, around the table hearing, with which I'm sure you're all familiar, which will be a discussion chaired by me, in which each party would have an opportunity to state its views, but no formal cross-examination is such. But in my experience, hearings tend to develop naturally into a rational discussion, and this can have the benefit of a better interaction between parties than can be the case with inquiries. And inquiries form the last option in the more traditional form of oral session, with procedures via formal evidence in chief and cross-examination, and probably now really only necessary where witnesses' views need a careful forensic examination. Now, my own view is that a hearing probably forms the best way for all parties, because matters can be dealt with normally on the spot rather than prolonged issues of written submissions. Perhaps we could start, Mr. Wallace. There have been references to further procedures and the extent to which we might need preliminary procedures, possibly in writing. Would you have any views on this?
Thank you, sir. Having reviewed the approach and based on our suggested additional clarifications from earlier, our client's position here is that our preference would be to proceed by way of written submissions, if possible, accepting that pending receipt of additional information, you may decide to form a view further down the line as to whether the hearing is required or not. But at this point in time, our preference would be to proceed by way of written submissions alone.
Thank you. I noticed that, in fact, that was the outcome in the King Tut case, where a hearing was anticipated, but following the pre-examination meeting, it was decided to revert to further written submissions. Does the council have a view on this, Mr. Devaney?
Yeah, thank you. So I think our preference would be for written submissions in the first instance, but also do appreciate, I think, the comments that you've made already that determining, matters where discussion, if there are matters that require that, it may actually be quicker and more expedient. But I think certainly, so I wouldn't want to rule it out, but I think certainly to begin with, we feel that written submissions would be a sufficient means to determine this matter.
Mr. MacLeod?
Sorry, I seem to have a problem with my mute button, but got there in the end.
Did you get all that?
I did, yes, sir. No difficulty with what's being suggested. I think that the question of whether a hearing is required or not is really going to depend on what comes out of the written submissions process, and whether you feel at that stage, sir, that you have enough of an understanding of what parties' positions are to proceed without a hearing. But we're content in the first place to have an exchange of written submissions and then allow you to review where things are at once you have the benefit of those to decide whether a hearing remains necessary or not.
Thank you. Thank you very much. I'm very happy to go along with that. We had suggested a date for Wednesday, 20th September for a hearing. So that is now giving us something like 6 or 7 weeks away. It's always difficult sometimes in these cases to keep the momentum going. And whilst I'm very happy to proceed on written submissions, I wouldn't want us to get into a situation where we're having an inordinate delay on this. And I'm sure that everybody will be happy to agree with that. It may be in the end that if we're going to look at written submissions, 20th September would in fact be too soon to revert to a hearing anyway, given the usual timescales that we're needing. But if everybody's happy, I am happy to agree to proceeding with written submissions, particularly on the issues which have just been discussed, and which really need the cooperation between parties to take those forward. And then, in due course, I can then consider whether we need to revert to a hearing or not. As I mentioned, certainly that was the procedure that was followed in the King Tut case, where in the end it was purely conducted by written submissions, and it may be that we have a procedure there in place which would work in this case. So I'll set out the issues in the notes of the meeting which I think need to be considered by further written submissions, and if people are happy with that, we can then go forward, and we'll set aside for the time being the 20th September, and if necessary we can always find another date in due course, but hopefully avoid having to have a round the table session. Is everybody happy with that way of moving forward? I see everyone nodding in that case. Now, the next issue had on the agenda was potential conditions, which people have referred to on a number of occasions in this discussion. We have already the council's list, and we have other conditions put forward by various parties. Perhaps it might be helpful if I was to set out areas where I thought there was particular need for discussion on the conditions. Obviously, a lot of the council's conditions don't relate to music and noise itself, and then we could deal with those through written submissions between the parties and hopefully reach some agreement on that. The extent to which that can be done will also, of course, relate to the other written submissions and discussions taken forward. But would everybody be happy with that procedure?
Yes, sir.
Yeah.
Agreed, sir.
On the table. Now, the next issue is that of a formal site inspection, which I will be needing to give me a clearer understanding of the issues which are being raised in all the written submissions we have. I have had a general walk around the site because it's not an area that I was particularly familiar with, and I was certainly unaware that there'd been a cattle market so close to the centre of Edinburgh in the past, and it is a very interesting site. But if everybody is happy, I would like to make an accompanied inspection of the site with access to all the relevant buildings, and particularly the interior of the O2 arena. Now, I'm assuming that every party would wish to be represented on that, and would you be happy for us to organise that?
Yes, we would.
We've got general heads. In which case, I'll get our case officer to write to parties, and we'll try and fix a date for an inspection, perhaps looking towards the latter half of August, giving people plenty of time for that. And then, if all parties could arrange to be represented on that, and to ensure that we have access to the relevant buildings. Is that procedure okay with everybody?
Agreed, sir.
Agreed.
Right. Right, now those are the points which I had covered on the agenda. So I'd like to know, are there any other relevant matters that we haven't discussed that parties would like to raise? Mr. Wallace, if we could start with you, please.
No further matters from us, sir. Thank you very much.
Mr. Devaney?
No further matters, sir.
Mr. MacLeod?
Nothing from me either, sir.
In that case, it simply, excuse me, remains me to thank you all for the participation. It's been, I think, a very constructive discussion, which is always very helpful for the reporter. So the next stage is that I will prepare a note of the meeting, which will then be circulated for everybody to comment and then take action in terms of the various discussions which need to take place as the next stage. Then I'll be looking forward to seeing the conclusions of that. I wonder if it would be helpful if I could set a deadline for the end of August for the completion of that, or is that going to be too soon? I know sometimes it can take a time for these things, but I don't want to delay unnecessarily. Mr. Wallace, is that reasonable, or would you think perhaps towards the end of September might be more appropriate?
It sounds reasonable, but pending confirmation of the availability of our technical advisors to undertake the required reviews. So if we could agree in principle that's the target, and perhaps confirm back via your case officer.
Mr. Devaney?
I think the period does sound reasonable. I'm just concerned about it running further. As you say, we don't want this to drag on. So it would seem reasonable to say at the end of the month, but if there is any need to extend that, given I think the points that Mr. Wallace has made, just with the availability of technical experts.
Mr. MacLeod?
Yes, we'd agree with that as well. Can I just clarify one thing, sir, just in terms of your next step? So you'll issue the agenda, you'll issue the minute of the meeting. Will that minute set out timescales for further submissions on different points from parties? Was that your expectation?
I hadn't given particular thought to the actual timescales, and I was wondering whether everything could be completed by the end of August. I can certainly put down timescales. A lot of the work which has already been done in relation to the noise assessments, I would hope wouldn't take unduly long to set down into paper and then start a discussion rolling. Is 2 weeks too soon for the initial contact on that? I'm aware that we are in a holiday period, and that sometimes the specialist experts can't be available. Because if we're to have if we're to have initial excuse me, written comments on the noise and then further discussions, we would really need to get something down within the next 2 or 3 weeks if we're to meet the end of September. We also got the parallel discussions on statements or the statement of agreed matters. It's looking as though perhaps if I was to say a 6-week period rather than the end of September might be more appropriate, and I can put some suggested deadlines along the way in the note of the meeting, which people can then comment on. Would that be satisfactory, Mr. MacLeod?
I think so, sir. It's obviously up to you as to what you find most helpful. What I had been thinking might happen based on what we discussed today was Mr. Wallace and the council would be asked to comment on both the Academy's most recent noise work, and also the conditions and deed of servitude approach that we had suggested, for the reason that our position, I think, is quite clear. We don't yet know what the applicant's position on those two matters are, and we don't really know what the council's position is either. So that seemed to me to be a logical first step, which would then allow the Academy to consider its position in light of those submissions, and then that might result in a response from us formally, and also a discussion taking place in parallel as to what we could present to you as a statement of agreed matters.
I think that all sounds very reasonable. I think it would be helpful for me, specifically in terms of the role of the deed of servitude, if you were able to give me a note of to exactly what this would entail and how you think it relates to the application and the potential grant or otherwise of planning permission.
Happy to do that, sir.
That would help me. Otherwise, I'll set things out in the note of the meeting. And in the meantime, the 20th of September for hearing, we will set aside, and hopefully we might be able to manage without that. Any further issues from anyone that we've not dealt with? No. In which case, thank you very much for your attendance. That's been extremely helpful, and I will be in touch through the case officer at an early stage. Thank you very much, everybody.